안녕하십니까?
Good morning. We will now start the inaugural International Symposium of Asia Pacific Competition Community, or APCC for short, on the theme of A New Frontier, Competition, Privacy, and Regulating Advertising in the Digital Era. I would like to extend a warm welcome to the expert panelists from Korea and abroad who will be presenting at today's seminar held virtually due to COVID-19, as well as to the participants joining us via online. I am a senior partner at Lee & Co. I will be your MC today. My name is Hwan Jung. A brief introduction to today's agenda. To commemorate today's seminar, KFTC's Secretary General, Mr. Bong-Eui, will give the keynote speech. From 9:15, Session 1, Regulating Digital Markets, Rethinking Traditional Theories in a New Context, will begin. At 10:05, we will start Session 2, What's the Harm? Is Data Privacy a Competition Concern? After which a 15-minute break will follow. And at 11:10, Session 3, At a New Scale, Competition Concerns in Regulating Digital Advertising will begin. We ask for your kind understanding for not being able to invite you in person to the seminar venue due to the social distancing guidelines during the pandemic. Today's seminar will be streamed live via YouTube, so please do stay with us till the very end. Without further ado, we will now start APCC's first international symposium. Secretary General of KFTC, Mr. Bong-Eui, will give his keynote speech.
반갑습니다.
I'm very pleased to meet you all. My name is Shin Bong-sam, the Secretary General of Fair Trade Commission, the KFTC. Please allow me to thank the APCC for setting the stage, allowing us to have timely discussions on key issues in the digital era we live in today. I would also like to extend my gratitude to the renowned domestic and foreign experts joining us for this discussion. I hope this first forum, organized by the APCC, launched last year, will be a great success. I am honored to be able to give a keynote speech at such an important occasion. Although the digital economy penetrates almost every aspect of our era, I would like to especially focus on the competition issues within the digital market, consumer issues, and the KFTC's policy direction today. In the present days, digital economy has already deeply been embedded in our everyday lives in major economies around the world. In response, the competition authorities in many countries are strengthening their monitoring activities and regulations of the digital market. Similarly, the KFTC formed an internal ICT team 2 years ago to strengthen the monitoring of online platforms, mobile devices, and more. As a result, the KFTC imposed strict sanctions on Korea's #1 search service provider for manipulating their algorithms in the world's #1 internet company for their abuse of market dominance. In addition, the KFTC is also dedicating our effort to improve the system. In June of last year, we announced comprehensive measures to establish fair trade order in the digital market and have been pursuing legislation. In January of this year, we submitted a bill to the National Assembly to ensure the enacting of Fairness on Online Platform Brokerage Transactions Act to ensure that a large number of small and medium-sized businesses trading through such platforms can coexist and grow with the platforms without facing unfairness. In order to create an e-commerce environment where consumers can transact with trust in their daily lives, we amended the Act on Consumer Protection e-commerce in line with the current digital market situation and made the legislative announcement in March of this year. The digital economy is rapidly expanding due to the development of information and communication technology and remote life patterns. 5G mobile communication was enabled in 2019, and the penetration rate of smartphones reached 95% this year. Online shopping has tripled over the past 5 years, and last year, more than half of all companies adopted a work-from-home policy due to the COVID-19 pandemic. The government is also actively supporting the digitalization of our economy. In order to lead the future economy in the post-COVID-19 era, the Korean version of the Comprehensive New Deal Deal plan was announced in July of last year, and the Digital New Deal project is at the heart of this plan. The purpose behind this is to create new services and jobs by promoting the collection and utilization of data in all industries. As the digital economy grows, goods, services, information, even communication is distributed online, and online platforms that act as a medium of this distribution have emerged as a major player in the digital market. Numerous small and medium-sized businesses are reaching out to consumers through these online platforms, while consumers of all ages are using online shopping on the other end. Platform companies have traditional financial businesses such as banks, securities, and insurance beyond just easy payment services and remittance. And there is even a case of a company growing into a large corporation by expanding further into mobility, entertainment, and other everyday life business. The expansion of digital market and the emergence of platform companies are the result of companies and consumers choosing the benefits provided by the development of ICT and platform businesses, but many market participants are also experiencing harms along with the benefits enjoyed. Above all else, even though small and medium-sized businesses have been provided with attractive business opportunities from platform companies, they're also suffering from unclear contract terms, disadvantageous burdens, and excessive fees. Many of these groups are announcing their public statements on their damages, and the National Assembly is calling for the KFTC's active role in resolving this matter. With regard to the so-called power dynamics, the KFTC decided to focus on providing basic norms for digital transactions and laying the foundation for a win-win situation rather than enforcing laws such as investigations or sanctions, since fair trade in the digital market also begins with a transparent contractual relationship. Furthermore, given that platform companies are the main drivers of the market's ecosystem that connects millions of business owners and tens of millions of consumers, it was deemed more appropriate to provide a foundation for the parties to innovate and grow together. Accordingly, the platform bill submitted by the government required platform companies to deliver written contracts that specifies its business partner or seller company's important rights and obligations, and provided the grounds for the KFTC to disseminate standard contracts, support the execution of women agreements, and conduct fact-finding surveys.
Consumers in the digital market are also suffering from various damages in the e-commerce transaction process. They're exposed to unclear information and frequently targeted by deceptive marketing. In particular, the platforms that have become the core of online shopping are not taking responsibility despite their various roles in the transaction process. In response to such issues that consumers face and in line with the current market conditions, the KFTC has decided to realize the obligations and responsibilities of e-commerce business operators and expand remedies for consumer damage. We plan to create a reliable and trustworthy transaction environment for consumers by ensuring that important information that enables the consumer's exercise of their right to choose, such as key criteria for product search rankings, how user reviews are handled, and whether customized advertisements are used, is disclosed transparently within a reasonable scope. Ensuring that platform companies are held accountable for misleading consumers to believe platform companies are the actual parties to the transactions or for their actual roles in the transaction process. Expanding remedies for violations of the E-Commerce Act, such as introduction of the consent decrees and activation of dispute settlement. We plan to amend the E-Commerce Act to fit market conditions, as the current E-Commerce Act was enacted at a time when catalog sales were the main method of transaction. As a small number of major platforms dominate the distribution channel within the digital market, market dominance is becoming a reality. Platform service prices are rising, whereas quality is decreasing. There are cases where competitors are excluded from the market and innovation is discouraged. In the recent Google case, where the KFTC imposed a large fine, the company that monopolized the mobile operating system was found to have hindered innovation by blocking the emergence of new competing OS products. Online platforms have structural characteristics that can lead to monopolization, such as network effects, concentration, economies of scale, and entry barriers. As such, the KFTC is paying particular attention to create a competitive market environment in areas dominated by a few large online platforms. Above all, the KFTC strictly enforces the monopoly regulation and fair trade law regarding the major platforms' abuse of market dominance by closely monitoring the market situation of large-scale platforms through a dedicated ICT team, preferential treatment of its own products by manipulating search algorithms, restriction of transactions with competing platforms, or request for guarantee of the lowest price against their business partners or sellers are subject to intensive monitoring. We're currently preparing to publish the guidelines for reviewing platform unilateral activities to enhance the transparency and predictability of investigations into abuse of market power by platforms. We intend to fully operate the relevant systems that have been recently introduced for M&A of platform companies. In 2019, the KFTC amended the KFTC's merger review guidelines to introduce anti-competitiveness standards for mergers in innovation-based industries where R&D is the key, and for mergers involving information assets. In addition, we plan to implement the transaction value-based reporting system from the end of this year to ensure that killer acquisitions which remove potential competitors will not be omitted from review. On the other hand, as there are cases where large platforms are expanding into related markets through M&As, we plan to closely examine the specific forms of such acts and their effects on market competition, and thoroughly examine whether there needs to be any revisions to the current review standards. In the digital economy, data is perceived as a core asset, an essential production element of companies. As explained before, the KFTC has already adopted an institutional mechanism to take this into account in merger reviews. In addition to traditional competition law issues such as anti-competitiveness assessment standards, new issues continue to emerge. With respect to competition and consumer issues, such as exclusive use of data collected by platform companies from users for their own interests, and consumer damage arising from data collection and usage, we plan to examine the market situation, domestic and overseas systems in further detail and conduct appropriate research. The KFTC's role will remain the same in the digital age. By laying the foundation for free and fair competition, our role is to create a market environment where innovators can continue to emerge, companies can grow their competitiveness through competition, and consumers can choose good products at reasonable prices. In the future, the KFTC will actively enforce law in the digital market while simultaneously working to improve the system further. As the digital economy expands, many phenomena are emerging as issues. Nonetheless, the KFTC will continue to pursue balanced policies from a comprehensive perspective. We will consider the importance of innovative competition in the digital market, along with its tendencies for monopolization and its fast pace of technological development and change. We also recognize how the digital market has different competition structures in each country. In particular, we acknowledge that platforms have a single ecosystem containing all parties, rather than a separate relationship between each business partner and consumer. As the digital economy has no borders and global companies are competing to reach domestic consumers, the KFTC will pay special attention to enforcing law without discrimination against domestic and foreign companies, and to guarantee procedural defense rights in line with global standards. I hope that this is a productive discussion to discuss key matters in the digital economy. Thank you for your attention. Thank you very much.
So thank you, Secretary General Bong-Sam Shin, for your words of congratulations on APCC's International Symposium. Next, we will begin Session 1, Regulating Digital Markets, Rethinking Traditional Theories in a New Context, which will be moderated by Professor Seong-Hoon at the Economics Department of Sogang University. We would like to invite the panelists to come up to the stage and take their seats.
Yes, greetings again. I will be moderating the first session. My name is Seong-Hoon. I am an economics professor at Sogang University. The theme for session 1 is regulating digital markets, rethinking traditional theories in a new context. And we have 3 very distinguished speakers joining our panel. First, Professor Sang-Seung Lee from the Economics Department at Seoul National University, also professor at the KAIST College of Business, Professor Mingy Kim, and also renowned professor from Harvard Business School, Professor Marco Lancini, is joining us today as our distinguished panel speakers. I don't think Professor Lancini is logged on and connected online just yet. We actually were very good about preparing ahead of today's symposium, but I believe perhaps there has been perhaps technical difficulty at his end, but he is not logged on just yet. So hopefully we'll have him join us later on, and we will ask him to present But if we are not joined by Professor Lancity, I am afraid that we will have to proceed with the two professors from Korea. As you know, the three speakers are all renowned, high-profile scholars in and outside of Korea in the field of antitrust. So for this session, we are very pleased to have this lineup of distinguished speakers. And also, it is my pleasure to be able to serve as the moderator. It is indeed my privilege and honor. So for each of the speakers, I will ask them to speak for 10 minutes each. And then we will also have a Q&A session. So first off, I will ask Professor Sang-Seung Lee to go ahead with his presentation, please.
I prepared my slides in English, so for my co-panelists, I will present in English. My topic is regulation and antitrust scrutiny of tech companies. So I'll begin by briefly talking about the recent global trends and what Koreans have been doing recently in this area. I will then pause to ask a question. What is special about digital platforms so as to draw all these scrutinies? A central concern seems to be that increasing returns to scale and network externalities combined with data lead to tipping to one platform at a global scale. The message that I want to deliver today is that Korea provides cautionary tale against the theory of irreversible tipping. First, search engines in Korea show the importance of localization. Second, social networking services in Korea show the importance of multi-homing. So global trends. As you are well aware, in the past several years, we have seen increasing antitrust enforcement against big tech companies. For example, EC has reached 3 decisions against Google. German cartel office recently enforced against Facebook. And also EC is investigating Apple, Amazon, Google. At the same time, in the US, the 2 antitrust agencies have filed antitrust complaints against Google and Facebook. There are private litigations by Apple, and also in Europe, Digital Markets Act, Digital Services Act have been proposed. At the same time, in the US, there are several pending legislations which try to prohibit self-preferencing killer acquisitions and also require interoperability and data portability. Now, Korea has been no exception. Indeed, you can say that in some areas, Korea has been at the forefront in enforcing antitrust law and enacting new regulations on tech companies. The prominent example is KFTC's recent decision against Google Android, which significantly expands the EC's prohibition in one respect. That is, Google is not just prohibited from requiring anti-fragmentation on smart mobile devices, but also on new form factors, including smartwatches, smart speakers, and smart TVs. And also, KFTC has been very active in enforcing the Korean law against the local tech companies, such as Naver, in the area of so-called manipulation of the search algorithms. And indeed, Korea is the first country in the world which prohibits Apple and Google from requiring the app developers from using Google's and Apple's respective in-app purchase mechanisms, drawing praise from the US Senator Blumenthal that the US should follow the example of Korea. Now, let's ask the question about what's special about the digital platforms. Creamer report, which was published 2 years ago, summarizes it quite well. That is, the characteristics of digital economy produce economies of scope, which give incumbents strong competitive advantage. The characteristics are, first, economists talk about increasing returns to scale. It's not a new concept, but what the Creamer report emphasizes is that the returns to scale occur at a global level, and the degree is so extreme that we will just see one platform. And there are network externalities, also data is important. So if you combine all this, the Creamer report goes on to say that large incumbent digital players are very difficult to dislodge. That is, tipping will occur to one platform, and once tipping occurs, it's very hard to other platforms to enter and compete. As a matter of principle, let me say that I am in favor of strong antitrust enforcement, but currently I think a little bit that the pendulum has swung a little bit too much in the other direction. So what I want to explain to you today is that Korean experience actually offers some counter examples against these arguments. And I want to emphasize 3 points. First is the importance of multi-homing, which Creamer report acknowledges, but doesn't say doesn't cite any specific examples. And second, although tipping occurs to one platform, it's not irreversible, because with multi-homing, sequential transition, which is slow, the gradual at first, but can accelerate as it happens, to another platform can take place. And third is the incumbent's ability to adapt to rapidly changing marketplaces and consumer needs. But let me first digress a little bit on the role of data, because it will be related to Professor Mingy Kim's presentation. That is, OECD stands for the well-known position that economics of data favors market concentration and dominance. And we will see winner take all. That is, one dominant platform will emerge. Some management scientists challenge the notion that data can confer an enduring competitive advantage because data is not inimitable, not rare, and not substitutable. So rather, the ability to process and analyze the data to create value is more important. So I think the role of data is, from an academic point of view, still under debate. Now, back to my main points. EC's Android decision challenged Google's business model as a whole. That is, Google prevents Android OEMs which license Google Android from releasing incompatible versions. That's called the anti-fragmentation agreements. And through the mobile application distribution agreements, OEMs are required to install all Google apps and install Google search engine as the default search engine. And third, through the revenue sharing agreements, OEMs are required to install Google search engine as the exclusive search engine. And the theory of harm is that all these agreements through all these agreements, Google is trying to cement the dominance of its search engine. And US DOJ's complaint against Google is quite similar to the EC's decision. Now, as an economist, we always say, where is the evidence? Here is the key evidence that EC presented. That is, from more than 10 years, Google search has been, the usage rate has been above 90%. And through all these agreements, Google is trying to maintain the dominance in search engine. That's the allegation. What's about Korea? At the top, it's not Google search. Rather, it's the local search engine Naver. Google is at the bottom with less than 20% of usage share. So this example shows the importance, in my opinion, of the localization. That is, global players, they try to reach the global audience and do not really try to localize its product to local needs. That leaves opening to local players like the Naver in Korea. Next, social networking services. FTC's complaint alleges that the relevant market is personal, quote unquote, personal social networking services, and Facebook has dominant share, and which is protected by significant entry barriers, including direct network effects and high switching costs. Now, the FTC's complaint was amended because the judge initially accepted, granted Facebook's motion to dismiss because FTC did not plead enough facts supporting dominance. Facebook still disagrees with the amended complaint, but here I'm not going to opine on the relevant market or dominance. Instead, what I want to explain to you is the difference between US and Korea. Okay. This is the data presented by the amended complaint. As you can see, the Facebook Blue, the Facebook.com, this is the terminology used by the FTC, has more than 200 million monthly authentic users, followed by Instagram, close. Snapchat is the third player, but smaller, and there is a very small player. So basically, the FTC says that there are 3 players. 2 of them are owned by Facebook. What about Korea? In Korea, there is a rich data set called Korea Media Panel, goes back to 2011. And by panel data, it can mean that the same individuals are followed over time. So each July, the respondents are asked, which SNS do you use most frequently? What's the second? What's the third? Okay. In 2011, when the survey began, Cyworld, which Koreans over 20 are well aware of, was the leading SNS service. Indeed, if you go back in time, Cyworld was almost 90% or close to 100%. Then Kakao Story, the Korean SNS service, was launched in 2012. In just 2 years, it reached or achieved close to 60% of usage share. Naver Band is still popular. Facebook has gained popularity, but look at the Cyworld. In just 1 or 2 years, it rapidly lost usage share. And also, the KAIST, the government think tank in charge of the conducting the survey, began including YouTube in the SNS category from 2019 in recognition of the fact that these services try to attract consumer attention. So they add features, delete features, launch new features. So now from 2019, it is KAIST's opinion that they offer social networking services like button and comment feature and so on. Now, outside of Korea, you may be aware of in the early days, Friendster and MySpace was popular, but rapidly lost share to Facebook. What I want to emphasize that although there is debate about the persistence of MySpace in the UK or US, in Korea, Cyworld was quite different. Indeed, many commentators thought that Cyworld's position was unassailable. So MySpace, it may have been very popular for just 1 or 2 years, but Cyworld was very popular for 5 or 6 years. So in some, unlike the situation in the US, in Korea, the SNS space is very fast-moving and dynamic space. So here I want to pause and ask a question. Is the Korean experience just unique to Korea or exception? Or are there some generalizable lessons that the Korean experience tells us? So my position is the latter, that there is lock-in effects or high switching costs, which are assumed by the theory of tipping, does not seem to apply to Korea. Why? Because of the multi-homing. That is, when Cyworld is popular, you use Cyworld, but Kakao Story appears. You use it simultaneously. And then gradually, if your friends or other users move to Kakao Story or Facebook, then you begin to use Cyworld less and less. So the tipping theory assumes that migration must take place simultaneously. That's what's meant by the high switching cost. But when multi-homing is easy, this transition to a new platform can be sequential. So here is the data on the multi-homing. That is, if you look at 2011, the respondents said that they used 1.7 SNS services on average. In 2020, it has increased to 2.1. And you can look at the composition, and you can see that indeed, even more compared with PCs, I think multi-homing is easier on mobile because it's so easy to download applications. So I want to sum up by saying that the theory of irreversible tipping, that has testable implications, and Korean experience seems to offer some counter examples. Thank you.
예, 이상승 교수.
Thank you very much, Professor Yi, for your presentation. So you compared the experience and the difference in the experience of the development of digital platforms in Korea and the United States. And it was an interesting interpretation of why there was this difference between the two countries. I'll invite the next speaker.
Professor Mingy Kim from KAIST. Please go ahead.
Thank you for having me here today. I'm Minky Kim from KAIST College of Business, and I'm very honored to present in this very first APCC International Symposium. As Professor Yi emphasized the role of data, today I'm going to briefly talk about how firms can create value using their data, especially in each stage of value chain. So I'm going to call it as a digital transformation later on. And I'm going to also talk about recent data competition spurred by a digital platform. So people often think that having access to ample data naturally brings firms a competitive advantage, but that is not true. To understand that, I want to take a moment to explain some concept and theory concerning the data business. So first, the digitalization. So digitalization is the firm's action to convert the non-digital information into digital input. For example, imagine the 5G-based smart factory. So it can instantly collect previously unobserved data. So, however, it does not necessarily change the value creation process. So on the other hand, the digital transformation goes beyond the digitalization. Why? Because it can create value. So again, in the case of smart factory I mentioned, firms can utilize the newly collected data to predict the potential malfunctioning event. So it can avoid the downtime and thereby save cost. So basically, using data create value. So we can call it as a digital transformation. So smart factory example shows that having data itself does not necessarily guarantee a value creation. So another well-known theory is a DIKW hierarchy. So according to that theory, firms gather information from the raw data, and then they transform information into insight or knowledge. So the B2B service provided by Amazon and Google, for example, the Google BigQuery, as you can see from the slide, and Amazon SageMaker, these are designed to help firms to create value from data. So if we want to discuss another concept is the data value chain, as you can see from the slide. So nowadays, firms actually create value in each stage of data value chain. So data collection, storage, and processing, and analyzing, and utilization. So when we discuss firms' competitive advantage in data, and then we have to discuss each aspect in each stage of data value chain. So nowadays, people talk about the value chain starts from the data production. So here's one example to show the firm's value creation from digital transformation. So I took this picture from the conference held by the Adobe. So people, the Adobe is a pretty well-known company, but it now becomes the global data business platform for B2B. So if you see the picture, in the middle of the picture, there's the customer named Sarah Rose. So if you look above, her digital footprint can be collected from all the devices, including desktop PC and mobile phones and IoT devices, such as AI speaker. So the data can be the first-party data or second and third-party data. The thing is, basically those data shows her on and offline activities. So including which app she installed and then purchase items and things she may want to buy, put in her wish list. So then the firms can combine all this data and transform this data into sort of insight. So in the form of customer profiling and segmentation. So if you look down below, I red box them as a value creation process by firms' algorithmic profiling. So then firms finally create value by recommending personalized items or inducing her upselling, like making her choose a more expensive item. So again, the data, this is a sort of the digital ecosystem. The data is a trigger point to enhance the value capturing mechanism for this entire ecosystem. Again, the data changes the system around the digital platform provider. So as more firms get involved in this value creation process, we end up with a digital ecosystem where some firms making money by more efficiently collecting data, and some other firms analyze those data to draw useful insights for other firms. So again, basically the players in this ecosystem rely on the user level data. So as mentioned by Professor Yi, then some firms can position itself as a gatekeeper by influencing or operating this ecosystem. Such firms are often called as a digital platform. And people are concerned about data concentration to those gatekeepers. Gatekeeper platforms could change the competitive landscape of digital economy. Why? I'm not going to spend too much time on this because Professor Yi already explained about the 4 characteristics of the digital platform. So basically, they can better predict the customer preference and thereby provide a more higher quality personalized services. And we have an economy of scale and economy of scope and a well-known network effect. Basically, the seller is more likely to join the platform if there are many potential buyers and vice versa. So due to such competitive advantage arising from the data, so customers, they don't attempt to switch platforms. So we call it as a customer lock-in. So this switching cost makes it harder for competitors to steal customers from the dominant incumbent platform. So due to those 4 characteristics of this platform with data, we can naturally observe another noticeable phenomenon, which is expansion of platform-based ecosystem. For example, I flash up the table taken from PwC report, which described how firms can do business with data. Firms can enhance their current business by generating new insight. So it can improve their ROI or customer satisfaction. And firms also enter adjacent business, or they can tap the new market by developing new businesses. So digital platforms which can access the data potentially as a gatekeeper can naturally expand its business territory horizontally and vertically. So here I present an ad hoc snapshot image I created previously. So typically, scholars use these 3 dimensions to categorize various online business platforms. So the community, content, and commerce. But as you can see from the figure, the criterion to tell them apart is a bit unclear and time varying as well. For example, the Facebook, they utilize customer data and then naturally expand its business toward the commerce nowadays. And commerce-oriented firms like Amazon, they offer entertaining visual content so that they can secure customers. Basically, they want to make customers spend more time on their own platform. So in other words, the customer data they can exclusively access, make them better predict the customer, and then make them expand their business territories, and it causes a shift in competitive landscape. And then, so nowadays it's true to, it's really hard to define the competition among these digital platform players. So here on this screen, you can see many different digital platform businesses. So, we can see them in our daily life, ranging from transportation, accommodation, to search and advertising. But if we slightly pay more attention to the potential gatekeeper, so we can see sort of the one layer which distinguish those digital players. I mean, in terms of data accessibility, 2 firms are quite outstanding: Apple iOS and Google Android. Why are they so outstanding? So again, from the perspective of ecosystem operator, all other players are just app makers in this ecosystem. So we can call these two firms as platform or platforms. So here's a more detail. So you can imagine what's going on behind the digital ecosystem from this figure. So for the past few years, as you can tell from the arrows in this figure, the Google and Apple, they allow many players, including the ad tech companies, to share lots of customer data. Indeed, the data, it was working as a sort of like a blood in this ecosystem. In fact, many ad tech companies and other relevant firms, they could maintain their business using this data. But then the platform of platforms I mentioned, they recently announced their plans to control the flow of user-generated data. So first, Apple's app tracking transparency, called ATT, it requires app makers to ask permission if they want to track down the customer's activities across other apps and websites. So remember the picture I showed you earlier, so with Sarah Rose? So those kind of picture becomes unrealistic under this new policy. And again, then the value creation is also not possible. So their announcement actually came as a shock to many players in this ecosystem. So it includes the Facebook. So recently, Google also announced the privacy sandbox for the purpose of protecting customer privacy. But once it is implemented, the ad tech companies in the digital ecosystem, they previously used the third-party cookies, but now after it is implemented, they have to make another contract, separate contract with Google to make personalized advertising. So then Facebook, which often call it as one of GAFA, it's becoming just a one app maker from the perspective of these two ecosystem operators. No wonder Zuckerberg got angry at Tim Cook, right? So it seems like Facebook now wants to launch the new and big data platform called the Metaverse. So we can tell it from its new CTO, but why Metaverse? Because all the users on this new platform, Metaverse, especially we are talking about the MZ generation these days, basically users, they allow Facebook to track down all the information over the customer online journey. So customer online journey is a sort of awareness, searching and comparing products, and purchasing and reviewing, etc. So they can collect all the information over the customer online journey seamlessly by themselves. So I think we can expect a new type of data competition among the global big tech companies in the future. So that's all for today. So thank you. And if you have any question, please contact me by email. Thank you.
카이스트
Yes, thank you very much. That was Professor Mingy Kim from KAIST, College of Business Management. The theme was value creation from data and also competition by or between digital platforms. So thank you very much. And the next speaker is from Harvard Business School, Professor Marco Iansiti.
컴페티션
And he's going to present with the title of Competition in the Age of AI. Or he was scheduled to give a presentation on competition in the age of AI. We do not know what extenuating circumstances there are, but we haven't yet contacted him. We haven't been able to get in touch with him yet. So we will continue with this session without Professor Iansiti's presentation. So we will start the discussion, and this is how the discussion was designed in advance. I will be, as the moderator, asking a question to all panelists. This is a general question for both panelists. And later, Professor Yi will ask a question or make a comment to Professor Kim. And Professor Kim was supposed to ask question or make comment to Professor Yancity, and Professor Yancity was supposed to ask questions and make comments to Professor Yi, taking turns between the panelists. So here I have put up the discussion material on the screen. So first, this is a question that goes to all of the panelists. It's a general question. And since it is in English, I shall read it in English.
Seems like a kind of paradigm shift is going on in antitrust and competition policy in online platforms and data-driven economies. To take a risk of oversimplification, it may be phrased as the regression to Harvard School's structuralism. Some people may call it new Brandism. As you all are aware, Linda Khan is at the frontier. He proposed strong antitrust enforcement against predatory pricing and vertical integration by big giant platforms such as Amazon. I would like to hear your opinion about whether we need such an antitrust paradigm shift in this digital era. 이게 제
So this is a question that goes to all panelists. And I will continue with the questions, and later the panelists will have a chance to respond. And next, Professor Yi's question to Professor Kim. Professor Lee, please go ahead.
I think already mentioned basically my presentation, my question to Mingy Kim, that is, what does he think about the role of multi-homing when you think about the role of data?
다음은 이제 김민기 교수님이
And then Professor Kim may direct some questions. Since Professor Yancity unfortunately is not here, I think we may have to skip that section, sorry. And we were supposed to also have Professor Yancity ask a question to Professor Yi. Professor Yi, you're here, so let me read that question instead.
How broadly would you scope the role of antitrust legislation and processes on curbing the adverse impact of digital platforms? Traditionally, the antitrust field does not have a tradition for implementing highly effective remedies, as demonstrated over the years, for example, in Europe. What kinds of remedies do you see as effective in remedying our current challenges? How do you enable the kind of innovation in policy that may be required?
So, two questions were asked each to Professor Kim and Professor Yi, and I think they are related questions. So if you could combine your responses to the two questions, we would appreciate it. So let's switch turns. Professor Kim first.
So let me speak in Korean since Professor Yancity is not here. So the moderator first has directed a question to all of us, and I've thought about it. And the context that I wanted to highlight is actually the role of data. So big tech companies, they may have exclusive access to data. For them, it's important to create a marketplace, and they play the double role as the athlete and also the umpire, and that is often cited as a problem. For example, Amazon is the most often cited case. So Amazon site users, people who visit their site, with their self-preferencing practice where the users are directed to preferential brands. They may create private label products and compete against third-party sellers on their platform. The problem is Amazon, they have a preponderance of data and much more superior access compared to the competitors. But for us, as I already mentioned, by data, we think of it as, an object, something. But from the value chain perspective, it's about the capability to collect, process, interpret, and utilize data. So for each of the different stages, there is competitive advantage or disadvantage. So just because you have it or you hold data, that does not necessarily mean that you have that kind of competitive edge. And so for the business platforms, there are different business models that we need to first understand before trying to regulate. For example, Uber is well known, and then Netflix is also very well known, high profile. But these companies, if you look at the course of their data-driven growth, it's not very recent, but um, there was an author who passed away. He wrote about the dilemma of innovation. He looks at these two companies differently. Uber, he says, was not a case of disruptive innovation, whereas Netflix was a case of disruptive innovation. So in other words, typically we say these are platform players that are enabled by data. But if you look at the process of innovation, also their business model, there are differences. When we talk about the traditional pipeline business, for the most part, the products and also business models were similar, more or less the same. But now it's totally different. It's really a very diverse lineup of business models. And to try to just regulate them just based on one conformist set of regulations, just going by outer appearance, I think has to be re-examined. We have to really look deeper into the underlying differences. These platforms, of course, are acting in their own interests. And then regarding consumer welfare, they may actually do it in a way to promote innovation and in a way that does not necessarily hurt the welfare of consumers. So we also need to examine and study that in further detail on a case-by-case basis. That's my first answer. And then Professor Lee showed the KAIST media panel data. I thought that was a very interesting piece of data. I would like to use it later on. Cyworld, multi-homing, that's all very interesting. So as Professor Lee said, yes, people are doing multi-homing. They're not tied to any one dominant player only. It's just naturally they're spread out across different platforms, weaving in and out with cross usage. And sequential transactions, yes, I believe that is happening. Economy of scale and economy of scope in particular, I think, deserves our attention. So I've thought about it. Basically, these digital platform players, they provide a bundle of information and services like email, calendaring. Google, for example, say I wake up in the morning, check my email, going to my Gmail account. There's something in my inbox, and I have to set up an appointment. And so I do it on Google Calendar. So I do it in groups. So there's already that network effect. And then my colleagues, the materials that they need, everybody uploads on Google Drive for sharing. And then during the meeting, we use Google Hangout because everybody has it. And it's very convenient to use. So this is the type of bundling strategy that is used to tie together different types of products and services together. So calendar or email services. There might be interesting standalone services that you might try out, but when there are seamless bundle services that a lot of people can use together, I think that will definitely have the effect of tying users to that dominant platform. So I do believe there is multi-homing in practice, so people are not necessarily tied. But because of this information bundling strategy, there is a bigger lock-in effect for the larger platforms. Thank you.
Professor Yi.
English, so I will speak in English. Lina Khan asked the right questions, but I'm hesitant to agree with her solutions. That is, presumption of anti-competitiveness based on a structural approach. Indeed, I have a long-standing slogan for a competition agency. That is, a competition agency should act. ACT. A stands for articulating the theory of harm. C stands for checking the assumptions of the theory against the realities of the industry in question. And T stands for testing the predictions of the theory of harm using available data. Khan's approach skips all these elements of an economic approach. As many of you are aware, FTC recently withdrew the 2020 vertical merger guidelines. What troubles me is the FTC's statement accompanying the withdrawal. The FTC says that the 2020 VMG relies on, quote, unsound economic theories, unquote. Lina Khan elaborates, quote, the VMG's reliance on EDM, the elimination of double marginalization, is theoretically flawed because the economic model predicting EDM is limited to very specific factual scenarios, unquote. As an economist, this is quite problematic because the elimination of double marginalization is just the opposite side of the same coin as unilateral effects. That is, merger changes the economic incentives. If you accept unilateral effects, it is natural that you need to accept elimination of double marginalization. Of course, you have to show how strong the EDM is. But seems that Khan rejects the theory of the elimination of double marginalization wholesale. That's quite troubling from an economist point of view. Next, Professor Liensti asks a really difficult question. It is somewhat easy to come up with a theory of harm, but very hard to devise proper remedies. Still, if I venture out, interoperability remedies in the area of intellectual property, including platforms, digital platforms, and remedies aimed at overcoming behavioral biases by consumers seems to be good candidates. Thank you.
예, 그두분
Yes, thank you very much to the two gentlemen's insightful responses. So thank you very much. I think we are almost past our due time already, but perhaps do we have any questions coming in from the floor or online? Are we able to accept questions or comments either from the floor or online? Or I understand now that we are out of time and not able to do that. So with that, we will have to conclude session 1. Thank you very much to everyone. And that ends the first session of today's symposium. Thank you.
네, 일부 사회 및 패널로 참석해 주신
So I would like to extend my gratitude to the moderator and panelists of session 1. Since we are running late, we will move on straight to session 2. Session 2 is on What's the harm? Is data privacy a competition concern? Mr. Youngjin Chang, partner at Kim and Chang, will be the moderator. And we would like to invite the panelists up to the stage. And once we rearrange the stage, we will start with session 2.
Okay, this is session 2. Following on the heels of the session 1, one of the key issues and areas of debate centering on the regulation of the digital market is related to data privacy and whether this is really a competition concern. I'm very excited to be moderating and exploring this issue with our distinguished panelists today. My name is Youngjin. I'm a partner at Kim and Chang's Antitrust Practice Group. Today, I'm very honored to be introducing our distinguished panelists for you. To my immediate left, Professor Bong-Eui, who is a professor at Seoul National University Law School and APCC co-chair. He is one of the most authoritative scholars in antitrust community in Korea. Next, Director Yong Lim, to the far left, Director of Kftc's Anti-Monopoly Division. He has a tremendous amount of experience in antitrust law enforcement in Korea. Very recently completed one of the most complex of the market dominant cases in Korea. Next, we have here on the screen the Honorable Maureen Ulhausen, the partner at U.S. law firm Baker & Botts. She needs no further introductions. She was former acting chair and commissioner of the United States FTC, Federal Trade Commission. Finally, Professor Sujin Nam of International Economics and Law at Hankuk University of Foreign Studies. Prior to becoming a professor, after graduating from Harvard Law School, she practiced in Axin, the antitrust specialized boutique law firms in the United States and Korea. To start today's discussion, I will turn the floor to Professor Bong-Eui to give his presentation. Professor?
예, 방금 소개받은 이봉규.
Yes, I am Bong-Eui, as was just introduced. Now, we come up with the data-related laws and competition-related laws and enforce them. And I think data privacy is one of the key issues that we also need to address. So in that regard, I would like to just recall that Secretary General Shin, in his keynote speech, mentioned an approach that no one can challenge. So if you heard his speech carefully, he used the expression comprehensive perspective and balanced policy. I believe this applies not only to data privacy, but also to competition laws and policies and enforcement thereof. Comprehensive approach, balanced policy, these apply to this area as well. So I believe that these two concepts will be themes that we need to bear in mind all throughout today's seminar. Now, I believe that since we have 4 panelists in this session, we don't have a lot of time on our hands. So although I did prepare my slide deck, I will try to summarize it and save some time for discussion later on. So the theme of this session is data privacy a competition concern? So this was the topic of my presentation as well. And regarding this data privacy and competition law, I would like to cite the FCO's decision from Germany. So I will discuss FCO's decision, and then I will discuss whether what type of FCO's decision, what kind of implications FCO's decision has to Korea. So these are my private opinions. Now, when we talk about digital economy, it's become a household word that even the children know of. So we talk about platforms and digital economy, and platforms are driven by data. And big data can have significant impact on our economy and society, both positive and negative. It will bring about both benefits and harms. That is the reality. But if you think about data privacy, I think we need to differentiate two concepts that will be very useful in our discussion. What I mean by this is that we can look at data as either an economic asset or a non-economic asset. So data, non-economic asset means it has values other than economic values. In the case of data as economic asset, we will be using that concept as having economic value, and we'll be discussing in the context of market and data monopoly, for example. But if you talk of data as non-economic asset, it will be related to data privacy issue. In that regard, we are using the expression data privacy, and I interpreted this as having a separate data privacy domain and data competition domain. So that focuses on the non-economic value of the data. And when we talk about data competition law, it is in the context of the competition market. So it stresses the context of competition in the market more than its privacy aspect. So I believe that it is desirable to separate the concept of data in two different tracks. And so my conclusion, I believe, is implied in my separation of the concepts. Now, when we talk about privacy infringement, how is that related to competition? Now, data as non-economic asset. Is this something that we need to consider when we make assessment of anti-competitiveness? I believe that that is the overall topic for this session. As you're well aware, when you talk about data-related laws, it's related to merger regulation, and it's related to market dominance or monopoly. And also, if we talk about the abuse of market dominant position, it is about the exclusive effect using data, or it is exploitative use of the users, for example. But regarding the exclusive use, we need to ask whether big data has the nature of essential facilitator, or how shall we look at the process of bringing about data monopoly and merger control. The merger between mega platforms, this will bring about the concentration of data, and then in this concentrated data in turn will be the basis of acquiring significant market power or attaining a market dominant position. So I believe that not just the scientific societies, but the enforcement agencies also need to take this into consideration. So now let me go on to the FCO's decision on Facebook. That was made in February 2019. And FCO held, as you're all aware, I'm sure that you're aware of the facts and you know the conclusion as well. So let me briefly explain. So Facebook, without obtaining users' explicit consent, gathered and combined data from various sources, and the FCO held that Facebook was violating provision 19.1 of German's antitrust law. And in the traditional competition law arena, the data protection rule was not considered, but this decision cites that the Facebook abuses market dominant power, which was not in terms of data privacy, which was not traditionally considered in the competition law. In that regard, this was a novel decision. And Facebook appealed the FCO decision to Düsseldorf Higher Regional Court. And then there was the Federal Supreme Court of Germany, in turn, supported FCO's decision. So we have to go back to the original case. So Düsseldorf Higher Regional Court decided that the relationship between the data privacy and competition law should be referred to EU's Court of Justice. And so it has been referred to EU's Court of Justice currently. As you know, from the very beginning, FCO made two unique decisions, or had two different approaches which were unique. When we talk about the abuse of market dominant position, and if it is a mega platform as big as Facebook, I believe that we have to apply Article 102 of EC's laws, and applying that Article 102 should be a natural course. But FCO did not try to apply this Article 102. That was something unique. And about 40% or about 100 pages of the FCO decision was dedicated to whether Facebook violated GDPR. So I think it was exceptional that FCO applied the antitrust law, Article 19.1 of Germany, to a case of this size. But I think dedicating such high proportion of their decision to GDPR is exceptional as well. GDPR is a protection of data privacy in Europe, and GDPR is effective in all EU countries, which means it's effective in Germany as well. So it's tantamount to violating Germany's data privacy law. So in conclusion, FCO did not apply Article 102 of EC's functional treaty. So I'm wondering whether the other EU nations will establish the relationship between data privacy and competition laws. That is unclear at this moment. And since this case is pending at the EU's Court of Justice, I think everybody was interested in the EU Court of Justice's decision. Perhaps we can have a consolidated approach after the decision is out. Now, another point I would like to mention is that FCO's approach is that data privacy is not excluded from the anti-competitiveness assessment, especially when the data has a critical role in the business model of the undertaking. The privacy issues are not per se excluded. That was the FCO's approach. And now regarding my thoughts on this, this is in my slide, the conclusion section of my slide. I have a question, or I have a doubt in my mind, which I would like to talk about. Now, data privacy, is this a consumer issue? Because data privacy is a fundamental constitutional right. And privacy infringement on platform is not only limited to specific transactions. So if we use the term or concept of privacy and approach the relationship between privacy and competition law, it becomes a human issue because everyone has a right to privacy and they have the right to choose not to have their privacy infringed. But I think this is a human issue, which is not a purely privacy issue, because this could also be related to the health area and other areas as well. So that's a question that I have in mind. And as for Korea's antitrust law, privacy infringement, how should we interpret this? If you look at Korea's antitrust law, abuse of market dominant power and unfair trade terms are the representative provisions. And regarding the abuse of market dominance, and as we can see that FCO interpreted it as exploitative use. Of course, FCO never used this explicit term of exploitative, but we can interpret that FCO viewed it as exploitative use of data. And so according to Korea's antitrust law, if we interpret such privacy infringement as exploitative use, this will cause appreciable harm to the rights of the consumers. Now, so appreciable harm to consumer interest, these two conditions means that we have interpreted this disadvantageous situation for the consumer as abuse of market dominant power. And so I think that is why it was very difficult to prove that this is abuse of power or exploitative use, which is why the court did not uphold the FTC's decision, KFTC's decision. So personally, I take this as the economic interest of the consumers when we talk about consumer interest. And as to how we interpret consumer interest, I think we can draw a line or limit the scope of how much it is related to the competition law. And even if we try to relate it with unfair trade practices, the same conclusion applies. So we have free services provided, and then on return, the users are providing data. If we take that as an assumption, we also need to debate whether this is a benefit in return or not. But at any rate, the data provided by the users, as I mentioned earlier, has the nature of data as economic asset. So the data provided by the users are not provided as data. The users are not providing data as non-economic assets. So in that regard, so this could be a benefit in return for the free use of the platform services. So ultimately, I think data privacy coming under the scope of unfair trade terms is not right. So Germany has a different situation than Korea, so we will have to wait and see what the verdict will be by the EU's Court of Justice. But what are some of the questions that we need to consider in Korea? Maybe these are some consideration issues. So firstly, we need to think about whether Korea's antitrust law violation can be considered as violation of data privacy infringement, or is it necessary to consider it that way? If we do this, there is an issue because according to the current data privacy law of Korea, collecting, processing, and fabricating data without explicit consent is an issue. And so we have to consider the abuse of market dominance power under the competition law we have to consider whether it is essential that we apply that approach to the infringement of data privacy. We have a lot of faults and at the system level. So even if we do acknowledge the need to connect the two concepts, if there are any faults, we would need to revise the data privacy law and then try to solve the issue that way. Or KFTC might apply the antitrust law directly to data privacy infringement. We really have to consider this issue very cautiously. And in the process of collecting and processing user data, there is a severe data asymmetry between the platform and the users, and there's lack of transparency. So regarding these issues, is antitrust law appropriate? Because it's an ex post facto law that is enforced. So I have a conclusion in the last slide, but I'll try to combine them together. So privacy law violation in itself, per se, does not make a violation of the competition law, because privacy is a fundamental constitutional right, and privacy protection is not the purpose of our antitrust law. And as an extension of that, we should not attempt borderless extension of competition law application. So I asked whether this is a consumer issue or not, but I think data privacy is related to environment and health. And even if we talk about consumer interests, there are different types of consumer interests. And if you try to address the violation of consumer interests using the antitrust law, that will not be feasible. And regarding data competition and data privacy, I try to distinguish between the two concepts. And if you try to pursue data privacy in terms of competition law, that will overwhelm the competition authorities, and this might invite political influence from outside. It might amplify this potential political influence from outside. That is one of the concerns that comes to my mind. So my thoughts are that whether it be consumer protection law or data privacy protection law, there are some weaknesses or shortcomings of these laws. And I think that competition law should not be used as a vehicle to correct the other laws, the data privacy protection laws or consumer protection law. Competition law should stay as competition law. In a way, data privacy is different from consumer interest. It's in the context of a larger discourse. And I think if we try to reduce the scope of data privacy to consumer interest, I don't think that is desirable either. So that brings me to the end of my presentation.
You raised a very interesting question, that is, data privacy concern. It's not just competition law concern. It's a much broader concept, like fundamental human rights. So I'd like to ask a question to the panelists. To address these concerns, in your view, which area of law, which legal discipline is best suited to address this concern, either competition law or privacy law? I will turn to Maureen first. Maureen, can you share your perspectives on this issue from the U.S. law perspective?
Yes. Thank you very much. So from the U.S. law perspective, I think we need to look at what is the harm that the law is trying to address. So if the law is trying to address the harm to an individual person whose privacy rights have been violated or who've had some sort of negative impact on them individually based on a company not adhering to the privacy bargain or promises that were in place, then that's very much a traditional consumer protection type of approach, right? So we would bring, we would have a privacy law or enforcement focus, or perhaps even an advertising law of deceptive practices. Now, under antitrust law, we're typically concerned about economic efficiency, right, and competition and the ability to compete. And so, for example, privacy could be addressed through that if you have two companies who are going to merge who are competing on their provision of privacy to consumers. And if they merged, then they wouldn't compete, as fiercely. This very traditional antitrust kind of concern. But one of the issues that we're seeing here in the privacy as an antitrust issue is a little bit of a policy at war with itself, because when there's this focus on companies having a large data set and their ability to use it to compete, to create new products or target advertising better. And then in a lot of people who are considering antitrust approaches, including in current legislative proposals in the US, what they're seeking is to have that company then have to share its consumer data more broadly, right? Share it with competitors, share it with people who the consumer didn't agree to have their data shared. So that idea that we're going to use this competition remedy, but in a way that actually is inconsistent with some of the consumer privacy concerns about data being too widely shared, too widely available, or available to those with whom the consumer has not agreed to transact. So I think that kind of shows why antitrust is generally a poor tool for addressing very valid consumer privacy concerns, and why more of a general privacy law that would apply to big companies and small companies would be a more appropriate approach. Because I'll just add one other thing, as a former antitrust and privacy enforcer, we saw some of the worst privacy violations and harms occurring not from companies that had a lot of market power, but often from companies that didn't dominate their area, but they still engaged in egregious privacy violations. So I kind of try to go backwards to say what's the remedy that you're going to try to impose, and does that really make sense when you start talking about consumer concerns about privacy?
Mm-hmm. Wonderful. Thank you very much for your perspective. Director Lim, can I turn over to you for comments? Before we do that, as a housekeeping rule, I'm speaking English for the foreign audience, but for this panel, you can choose which language you would like to use as you see fit. Please.
Yes, I am Kyung-Hwan Lim from Kftc. What I would like to discuss today is the data privacy protection issue has not been actually dealt with at KFTC level, but we do have some issues or cases related to data privacy protection law. And as to whether data privacy is a competition concern or not, I don't think we have an official position of competition authorities. So I just want to mention that what I'll be talking about is purely my personal opinion. Now, regarding data issues, we do have some precedents related to fair trade law, and we revised our merger review guidelines in 2019. And we had set a concept of information assets. And if there is a merger including information assets, how shall we assess the anti-competitiveness of that merger? And we came up with some consideration requirements. One is substitutability. So if the parties to the merger, when after merger, so we're considering whether the competitor also is able to have access to similar level of information assets even after that merger involving information assets. And also, will the merger increase the potential for restricting access to the information assets by the competitors? And so these are the considerations that we look at. So our assumption is that data is traded in a market, and in this data trading market, we're trying to assess the anti-competitive effect of this merger involving information assets. And lastly, in terms of collecting and utilizing the data, will this lead to the compromise of quality of service related to the collection or analysis and use of the information assets? And will this lead to a restriction of competition? So we have these 4 categories when we consider the anti-competitiveness of a merger involving information assets. That was the guideline that we came up with 2 years ago. And last year, we actually applied this guideline to the merger between the food delivery companies 배달의 민족 and Yogiyo. In Korea, we have food delivery apps, 배달 민족 and Yogiyo, and they merged in last year. And we had to make a decision regarding the impact of the information asset on the competition. Now, there are some information from the delivery app market, and it might slow down competition in order to attract restaurants. So from the consumer point of view, the issuing of vouchers or coupons, those types of incentives might become undermined due to the merger. And so we were thinking about this unilateral or one-sided pricing possibility, and we took the information asset approach to this decision. So, and by the way, the information asset I'm referring to includes consumer information, restaurant information, transaction information, and delivery information. So if such information assets can be acquired through other channels, in other words, in terms of substitutability, I don't think the merger, the decision was decided that this did not lead to undermining of substitutability. And before the merger, the Yogiyo and the parties to the merger were using information assets, process them and analyze them, and provided it in the form of marketing information to restaurants, and that incurs cost. So if there's a merger between these 2 parties, there might be compromise in the competition in the effort to attract restaurants, which means that the restaurants will not have access to marketing information as much as they used to. And so this was a decision where we considered information asset having an impact on competition. Another case is related to the abuse of market dominance. This also took place last year. Naver is Korea's #1 search engine. And in terms of platform that provides information on real estate for sale, Naver is also the #1 service provider. So to the content providers that provide real estate information, they receive information from these CPs and then put them on their platform. And what Naver did was that they prevented these information providers from providing their real estate listing information to rival platforms. So in terms of data, there is a data trading market, and in this market, Naver has a market dominant position. And so I think we can look at this as Naver abusing their market dominant position in terms of applying an exclusive condition in this data trading market. However, we have not had any decision yet directly addressing data privacy issues. Now, I think I agree with what Professor Lee said. Of course, this is all my personal opinion. Now, regarding data privacy protection, in Korea's legal framework, we have personal data protection law, and we have consumer laws as well. And I think regarding data privacy issues, in principle, we should apply the data privacy protection law or the Framework Act on consumers. So I think utilizing and collecting data that does not violate the scope of the consumer's interest, I think we can apply that Consumers Act on e-commerce. Now, as for does the data privacy infringement have an impact on competition? I think if the privacy infringement does have an impact on competition, it could be interpreted as a competition law issue. However, I don't think there will be many cases like that. When we talk about consumer interest, we should limit it to economic interests of the consumers within the context of competition law. But when we talk about data privacy, the consumer interest goes beyond simple economic interests. So personally, if it's something that is traded, we could look at it as having economic value. For example, we drink water when we're thirsty, or we trade real estate in order to acquire a property, and these are some subjective utility areas. So from a subjective utility point of view, how much data is provided to the platform, and in return, how much of the social media services and other benefits you get from the platform. So I think the same principles apply to this. If you consider it as transaction, then it could come into the area of competition law, and the data can be interpreted as having economic value. Now, depending on the trading terms, or in terms of receiving a benefit in return for providing the data, and if there is infringement of data in this process, I think if we could take a quality of service approach, we could interpret it as the data not having economic value. However, as to how many of these cases will happen, meaning how many cases of data privacy infringement having an impact on competition, I believe that there will be very few of cases of such kind. So the other panelists talked about some cases, but we haven't had any cases like that. So if we turn our eyes to overseas decisions, I think there were two examples. So the first example would be the Facebook decision on Facebook. So the market dominant player collects and uses personal information without getting explicit consent from the users, or use it beyond the scope of their consent. Should we look at this as a violation of the competition law? Now, if such conduct does not exclude the competitors, we could consider whether it substantially undermines and harms consumer interests. That's one possible approach. But as to whether we're going to regulate it as an exclusive conduct, I think we need to consider more points. So was the explicit consent given from the users during the data collection process? So if we focus too much on the transparency of the data collection process, it's also possible for platforms without market dominance to engage in such conduct. So it would be difficult to apply competition law in such approach. But if we look at it from a different, if we frame it differently, let's say they are fully aware of what the users are fully aware of what they're consenting to, and they're giving the data and in return for search services or social media services. Since those services are provided by market dominant players, sometimes they're uncomfortable about giving more personal information than they would like to, but they are giving those personal information because of the services that they get in return. Then we could link the provision of personal information and the provision of service. Then we could look at this as infringement of the consumer's rights to choice, and perhaps it could be regarded as an abuse of market dominance. And also we could interpret it as exploitative use of data. And from the perspective of whether this has an impact on competition, if they have the nature of exploitative use and they collect personal data and use it beyond the scope of the user's consent, and if this in turn strengthens the service provided by the market dominant platform and gives competitive advantage to the market dominant platform, I think this does happen to a substantial extent in reality. And then this has a competition factor involved, and I am wondering as to whether we can regulate it from the exploitative use point of view. If there is exploitative use involved, in the case of United States, I understand that they are not regulating such conduct. This is because the market dominant platform causing harms to consumers, the consumers may switch to another platform. And even if there is no competitor, there could be a new platform who enters the market. So rather than regulating the act itself, when there's exclusive use, it is correct. I think the US philosophy is to regulate the exclusive use rather than the exploitative use. In Korea, we do regulate exploitative use, but the ratio, the proportion is not high. So if there is a systematic entry barrier to new players, we only limit our exploitative use approach to such kind of cases. So we have not yet had any law enforced regarding from the exploitative use point of view. And as for regulation of exploitative use of data, I think based on our 10-year experience, in these platforms, we have tipping effects or entrenchment effects, which are stronger than we anticipated due to the tipping effect. And I think European scholars believe that the regulation of exploitative use should be more actively utilized in the age of these digital platforms. In particular, regarding data, in the case of Korea, we have this data portability requirements, which has not been legislated yet. But we're trying to give the portability rights to consumers only in the financial sector. And we have discussion about legislating such law to that limited scope. So we don't have an institutional framework or infrastructure for the consumers to switch. And in that regard, we could take a more proactive approach in terms of exploitative use of data. Now, if we do actually enforce these regulations, I think we need to take a case-by-case approach as to
법원이
which type of act infringes those competition laws. In early 2000, we had a lot of cases and had the decisions ruled from the courts. But the court was looking at appreciable harms to consumer interest, and they applied a very strict criteria. And the appreciable harm to consumer interest, proving that has a very high entry barrier. It's very challenging. And maybe the undermining of the quality of service to the consumers could be a point of debate when it comes to appreciable harms to consumer interests. And also when the quality of data is undermined, the personal information of the consumers, how much of an appreciable harm does it make to the consumer interest? I think if we do have an actual case, we should take a full review of that possibility. So my personal opinion is that we need to be more proactive in enforcing these types of regulations. Just one more point, if I may. If I may make just one more point. Regarding exclusive abuse, we had some actual cases. For example, Google's acquisition of DoubleClick or Facebook's acquisition of WhatsApp. The U.S. competition authorities made decisions, and in the process, I think regarding whether the data privacy is a competition concern, they did give some thought to that. So the Google's acquisition of DoubleClick, I looked at FTC's decision on that merger. I think privacy issue was not considered to be a competition issue similar to environment issues or labor law issues, but it could, if it was interpreted as having a non-price competition impact, then we could consider it as having an impact on competition law. But if the merger amplifies but we don't have any evidence of the merger bringing about amplification of the negative impact to the consumers' rights. So I think that's why the FTC ruled the way they did. So I'm not too sure about it because I don't know the details. But in terms of merger, if post-merger has, or if it exacerbates the data privacy infringement, in that case, we should assess the anti-competitiveness from the non-price competition point of view. But I don't know as to how problematic this will be because we haven't had any precedents, so we don't have any specific guidelines in assessing the anti-competitiveness. So in the future, if we do have such cases, I believe that we will be able to engage in more active discussion.
Your thought-provoking the comments on Professor Lee's presentations. Actually, you touched upon my second question. So maybe I can skip your comments for the second question. As you all know, based on the presentations given by Professor Lee, it appears that competition law and privacy law have evolved and been operating in a different universe. But in recent years, there have been a tremendous amount of debates as to how the competition authorities in their competition law assessment should treat a privacy issues. I just wanted to get some thoughts from the Maureen first, and then I'll turn over to Professor Nam. Maureen?
Yes, so thank you. So privacy law and competition law, they, as I said, they pursue different goals, right? And so they should be in different universes. But the issue about whether data, consumer data, can sometimes be an important competition issue, I think is without dispute. So when you see, there have been cases that look at, mergers that combine data sets that are hard to replicate, right? Like data about land records, data about credit reporting that are, consumer data. We have, I have brought, when I was at the FTC, we brought some cases that we're looking at that we had settlements in it. So I think one of the challenges here is that there is this presumption, however, that consumer data, general data, is both too freely available, which creates privacy concerns, and yet somehow restricted, right? So that we need to force companies who may have a lot of consumer data to either stop collecting it for an antitrust reason, which is a little curious, or compared to a privacy law reason, or force them to share it. And that's one of the things that I've often found a little puzzling, is actually because it is something that is actually rather widely available, right? So the FTC, when I was there, we did a report on data brokers. These are not the big online companies, they are 9, we looked at 9 of them, there are many more than 9. That collect and consumer data and create profiles, and those profiles are available to others who want to buy them to compete in the market. So I think, again, we are, having this debate because it's a desire, I think, to use privacy as a tool to say, well, there are some companies that we think have either amassed too much data or are using it in a way that is, objectionable. And if we think they have too much data, I'm not sure it's actually a competition issue. It may be a regulatory issue, or if we're concerned about how they're using it. Because if that data is also available to others in the market, then, it's kind of a curious thing to bring antitrust law to bear, because we don't have barriers to entry. We don't have, the other kinds of indicia where, antitrust law would get concerned. So I think, again, kind of going back to one of my initial points, yes, if you have 2 companies that are competing on who can provide the most privacy protective product and they're going to merge, that would be a traditional antitrust thing that we should look at. Or if there is a data set that's hard to replicate and the merger is going to give someone market power in it, that's another very traditional approach. But once you get beyond that, I think the lines and the goals get extremely murky. So not separate, but perhaps they should be, the analysis should be more separate.
Great. Now I'd like to turn over to Professor Nam. As I give some introduction, about your background. You practice law in the United States, in Korea. From your perspective, do you think competition authorities, should privacy concerns in their antitrust assessment? How much weight you need to give to privacy concern in your antitrust assessment? It would be great if you share with us on this issue from comparative law perspective.
Thank you very much. So I think Director Lim earlier mentioned the exploitative abuse cases and in Germany and some thoughts that are developing within Korea. And I think the essence of the competition problem in those cases is, I think, as articulated also by Director Lim, the idea of data advantage. And in order to address that issue of incumbent firms having data advantage, restricting competition, there is that exploitative abuse way of treating that issue. Other methods that have been proposed in other jurisdictions in the US, in Europe, and elsewhere are measures like increased interoperability, data portability, and sometimes even mandated data sharing. And when you look at these issues, the point that I think is echoed already becomes obvious that the two regimes have very distinct goals. And if you think about data portability, it is a point where the two goals may converge, in that data portability is supported by the rights advocates supporting privacy, as well as competition policy objectives of having, switching made easy for the users. But if you move to interoperability and also mandated data sharing, that's where the real tensions emerge, and it becomes obvious that the two regimes have very different goals. Interoperability is really having two or three different computerized systems interconnect with each other, and that is proposed by many competition advocates in various jurisdictions to tackle the data advantage problem. And that entails problems within the data privacy universe because it would be difficult to get explicit consent on the scope of the sharing, and in order to achieve all of the competition goals, which is to increase network effects, it would entail lots of sharing, but that would be difficult under the data privacy regime. So that interoperability is itself a very good example of the tension between the two goals. And mandated data sharing, I don't think I even have to explain why there's that tension. But having incumbent companies share their data of customers or others, that would obviously raise issues under data privacy laws. And I wanted to sort of mention the purposes of the Korean respective regimes. The Korean Personal Information Protection Act, if you read the first article, it actually highlights that the purpose of this act is to protect the freedom and right of individuals, whereas the monopoly regulation and fair trade law, the goal is collective in nature. And individual rights-based analysis has a whole different set of things to consider, and usually are set under maybe proportionality analysis, whereas the collective competition goals are analyzed under economic analysis, and that is a trend internationally and is achieved through maximizing consumer welfare. And however it is defined, it's the collective interest of consumers, and it's very different from the individual rights vindication sort of regime of privacy law. So I think even from the comparative perspective, if you look at what's going on in other jurisdictions in terms of competition policy for digital platforms, that tension becomes very obvious.
Thank you, Professor Nam. Thank you very much for sharing your comparative law perspectives. With our remaining time, I'd like to turn back to the Professor Lee again, because Director Lim, questions about Professor Lee's presentations. Also, Professor Lee studied in Germany, so he is best positioned to make some observations about the implications of the FSO decision. Professor Lee?
예, 사실 임경한
Well, actually, Director Lim's comments I do have a lot of comments that I would like to add to Mr. Lim's comments, but I will just mention one or two. I don't think we can come to a conclusion here and now, but for future discussions, I will make some comments. Now, we talk about non-price competition, which was mentioned often by Mr. Lim. And when it comes to non-price competition or non-price competition elements, I fully accept that concept. It is widely recognized as well. What I wanted to mention is not about the non-price competition. My point is about non-economic elements. By non-economic elements, it is something that is not related to the market. And we have competition for honor or competition for safety, competition for environment protection. In that regard, we can expand this to non-economic element. As for non-price competition element, I don't have any differences from Mr. Lim's comments. Now, regarding FCO's decision, since you asked for my views on that, I think going forward, if we apply similar precedents or if we have discussions on the Korea's antitrust law in the future, I think we have to consider the differences between the antitrust laws between two countries. So personally, this is what I think. First is that the law or the legal grounds that FCO cited was Article 19.1. And if you look at the examples of the abuse, there are some trade terms that are not valid or unfair trade terms. So this provision cites examples of where unfair trade terms are imposed, but it did not cite this provision. Rather, they cited provision 19.1, meaning that it's a general article saying that the abuse should not be done. So FCO stipulated that there should be no abuse of market dominance in the first clause, but they did not apply the second clause about the unfair trade term imposition. But in Korea, we don't have such laws in place. We have a positive list system or negative list system in our laws. So in that regard, so how should we limit the scope of consumer interest? That's a question, because the purpose of antitrust law, what is the purpose of the antitrust law? And also Korea's Supreme Court has been consistent when there has been mention of interest. So when we have common interest, it's all about economic common interest. That's what our precedences have shown. So economic means, in the antitrust law context, I don't think we can expand the assumption to non-economic domain. So in Korea, our laws are different. We have the appreciable harm and unfairness and these types of negative list approach. So that's how Korea's law is different from FCO's law. And secondly, as you're well aware, this FCO decision was not about abuse of price-related competition. It was about the trade terms. And we distinguish qualitative abuse and quantitative abuse. And if it's related to unfair trade terms, it is regarded as qualitative abuse. And it's very rare to find cases of qualitative abuse. But there are a handful of cases of abuse of trade terms. And this can be problematic when it comes to the contractual relationship. If a party to the contract abuses the dominant position in the contractual relationship to the other parties to the contract, then they are imposing unfair trade terms to the counterparty to the contract. There are rare cases, but in the past we did have some cases like that. But looking at this from Korea's antitrust law, the nature of such case is close to abuse of market dominance. So if we try to look for similar precedences, providing disadvantages based on unfair trade terms, these are notified in Korea as interrupting or interfering with a business. So even if it's the same behavioral pattern to abuse of market dominance, it varies depending on the decision. So FCO chose to make their decision based on Article 19.1 and not 2. And this comes from the unfair trade terms. This is something that we have to bear in mind. And this is related to the enforcement framework. In Korea, this is something we cannot ignore. So it's about the jurisdiction between different regulatory bodies. But I am not too familiar with a data privacy law in Germany, although I did stay there a long time ago when we did not have GDPRs and such. But based on my limited experience, the data privacy protection framework in Germany is under GDPR. So it's a regulation, GDPR. So it applies to all of the EU member nations and becomes effective without going through national legislative processes. So all EU nations have to comply with GDPR because it is at the highest level of the legal framework in EU. And under the GDPR, they have mandated some terms of references to the competent authorities in each EU nations. So in Germany, there is no reason to enact a separate data privacy law that the service providers should comply with. There is something called BDSG in Germany, which is tantamount to Germany's Data Privacy Protection Act. And this only is limited to the terms of references mandated by the GDPR. But the name of the law is Federal Data Privacy Protection Law. And then there are states, provinces in Germany, which have their own rules and regulations. But when we say federal, the Federal Data Privacy Protection Act ultimately does not stipulate the requirements of the businesses, but the government authorities in the case of Germany. So the BDS enforcement agency is the Federal Council for Data Protection, and their responsibility is to supervise the government agencies in the context of data privacy. So this is entirely and completely different from Korea's data privacy law. So FCO does not need to consider the federal data privacy law or the Federal Council's rules and regulations. This is different from Korea. So there's no issue of stepping on each other's foot in terms of jurisdiction. But if you look at Korea's data privacy law, in various articles and provisions, the processing of data without explicit consent is banned. And we have the Data Privacy Committee directly reporting to the minister. And so the data protection law versus competition law, the relation between the two and the relationship between the competent authorities of the two are very different from the situation in Germany. So we can't actually draw a clear line between data privacy and competition law. Of course, there are some relationship between the two, but the governing laws and regulations in Korea are more complicated compared to EU or Germany, and we have different competent authorities which might have overlapping jurisdiction in Korea. Thank you.
For your comments. We could spend much more time discussing this fascinating issue in more detail, but unfortunately, we are running out of time. So I'd like to thank Professor Lee, Professor Nam, Director Lin, and Maureen for taking your time out of your busy schedule. Thank you very much.
네, 2부에 참여해 주신 전문가 여러분 감사드립니다.
Thank you once again to the panelists joining us for session 2. We are running slightly late, but before starting session 3, we will take a short break. And I will see you back here at 11:35 for session 3.
네, 3세션 시작하도록.
Yes, we will begin session 3. I'll be moderating in English, and the speakers will be presenting in English. And during panel discussion, you may use the language of your preference.
난설원 Choi, professor at Yonsei University Law School, the moderator for this session. In this session, we will take an opportunity to look at digital advertising, its problems and regulations. In this session, 3 speakers will give their ideas and comments. To begin with, Mingy Kim, sitting next to me, a professor at Konkuk University Graduate School of Business, will give us a main presentation for this session. Following this, Professor Yong Lim of Seoul National University Law School and Director Seong-Hoon, Director of Consumer Safety and Information Division at the Korea Fair Trade Commission, will discuss Professor Kim's presentation on the topic. Regarding the issues related to digital advertising, I believe that this session will provide a great opportunity to listen to the diverse opinions of the experts from 3 different fields such as the business academia and the legal academia and the regulatory agency. And we welcome questions from the floor. However, for the time management and efficiency of the discussion, we will first listen to all of 3 expert presentation and comments. Then, if time allows, 1 or 2 questions from the floor may be available. Before we have a main presentation of the session, I'd like to give you a brief introduction to Professor Kim. Mingy Kim is an associate professor at School of Business, Konkuk University. He also works as an external advisor for domestic and international organizations. His research interests include platform business, business strategy, entrepreneurship, and innovation management. As you may know, the session is already behind the schedule. One of the most important tasks of the moderator is to keep the schedule of the session. Professor Kim, please keep in mind that you have 20 minutes for the presentation. Please start your presentation. Thank you.
Thank you. Thank you for the introduction. I try to my best to take control of that. Okay, thank you for your introduction. I do my best to. Okay, my name is Mingy Kim, and I'm from the Konkuk University. And today I will present about session 3 regarding digital advertising, especially focusing on overview from business perspective. So, advertising industry is really changing as we. Advertising is really changing, so we call this is like a digital transformation. As you can see in the figure in the below, so digital advertising spending in the worldwide is continuously growing. So advertising critical component, because the reason is simple, because advertising is really critical and crucial components of business growth. So ever increasing internet and mobile users, the companies have increased their digital advertising spend. So digital advertising refers broadly to advertising content delivered to users through various online channels. So global advertising is in 2020 is valued at $378.16 billion. This is almost 58.2% of the total expenditure on media advertising. This is really interesting because, as we know, 2020, 2019, and even 21, we have on the COVID-19 issue. However, total digital advertising is still growing up. And this is also, digital advertising really important in these markets. And while advertisers have increased their digital advertising spend, they continue to spend healthily on other forms of advertising as well. Let's move to the Korean digital advertising market. In Korea, the digital advertising spend in 2020 marked a 52.6% rise from the 3 trillion Korean won spent in 2015. And meanwhile, advertising on print and broadcasting remained relatively stable despite the COVID-19 issue. So from 2015 and 2020, digital advertising continuously growing up, and also even print and broadcasting, even though these two channels are slightly going down, however, we also need to thinking of the COVID-19 issue. So based on that, actually, they are also very stable in the market. And third one is, what is the different and what is the specialty in the digital advertising segment? In Korea, please check the table below first. So this is the internet advertising segment by media in Korea, April 2021. So in Korea, domestic service or sites account for a large proportion of advertisement compared to the EU and other countries. So from the e-market, their report in 2019 and 2021, actually, especially France and UK, they are really big issue about the duopoly for digital advertising segment. For instance, in France, over 60% is dominated by only 2 companies. So we know the Google and Facebook, and UK is similar. However, compare with these 2 countries, in Korea we are really diverse. So I believe this is really healthy compared with other countries. And existing media companies have quickly adapted to the expanding digital advertising segment, secure revenue from online advertising. So digital advertising has allowed the number of brands and that advertise online to increase significantly. So we can forecast the prospective evaluation. So digital advertising has steadily increased despite the pandemic. And although digital advertising segment as a share of total advertising market is increasing overall, the ratio of growth is slowing as traditional advertising channels innovate to meet competition from digital channels. So we can say, just as web ads boost in-store sales, online advertising also boosts the advertising market as well. Now, I want to introduce about some features and characteristics of digital advertising. So I summarize this as a 4E. So from advertiser perspective as well as a consumer perspective. So first one is economic feasibility, and second one is efficiency, and third one, effectiveness and fourth, entertainment. Let's talk about the economic feasibility first. So due to the characteristic of digital advertising, this is really cost effective. So it results in more leads with the same advertisement because cheaper, which means cost effective. And second one is return on investment. So under the digital advertising segments, advertisers actually facilitates measurement of ROI and switching the switching to advertising venue that delivers at the best ROI. Because from the advertiser perspective, they can handle and they can control their advertisement on dashboard in the real time. So this is really important for return on investment. And third is less expensive. So let's thinking about the TV commercial and newspaper printing. So if advertiser wanted to advertise their ads on TV commercial or newspaper, spending a lot of money. However, for instance, like using CPC or CPM model in digital advertising, only $10, $20, you can do your digital advertising. So less expensive is really important for SMEs especially. So allow small to medium businesses to engage in focused advertising campaign at lower cost. And last one is easy. I believe all audience in here, if I just teach like less than 1 hour, all of you in here, you can deliver, you can control and measure and managing digital advertisement in dashboard. And second one is efficiency. The tracking on engagement and click, comments, advertising sharing by user, etc. So the advertisers has ability to better measure conversion rate. So that is whether user purchase the advertisement product. And also, they have ability to measure the advertising campaign success. So that is what appeals to users and what does not. And it also allows the advertisers, allow the advertisement to operate the peak efficiency. And third one is effectiveness. For advertisers, digital advertising, advertisers can more easily select what to show and when and where to show content to the target customers. And for customers, the customers will be more likely to see advertisement about products and services of their interest. And last one is entertainment. This is also a very interesting point of the digital advertising. So by enhancing the ability to target content to the targeted audience, targeted advertising allows for more meaningful interaction with the consumers. So consumers may also feel more inspired by or satisfied with the advertisement contents. So we call this like advertainment because from the user side, advertisement is not information anymore. So they are information as well as they are one of the entertaining things and fun things, fun factors. So for today's session, in my personal view, today I can summarize like this. And the first one is convergence. So advertisers increasingly use a holistic approach to advertising by combining traditional as well as digital advertising to find mix that will maximize ROI. There is no advertisers only, for SMEs, of course, so there are some advertisers who only choose digital advertisement. However, usually the middle and big advertisers, they choose both. So to maximize their return on investment. And second one is, so in other words, we can say traditional and digital advertising converge as a result of technological development, both in terms of targeting and measurement. And this is a very important issue, important factor in digital advertising segment. And second one is increased alternatives. Because of digital advertisement, because of technology development in digital advertising segment, there are so many diverse method, digital advertising method or way of the method. So I can say, so there is ad inventory, and also in the video advertisement, you can choose a mid-roll and pre-roll and end roll, and also you can choose a CPC model, CPM, CPE. There are a lot of different types of alternatives we can find. So with the development technology and the expansion of network, various new forms of media have appeared. So from the advertiser's side, there are a lot of options they can choose. And therefore, that it is now possible for advertisers have more options to engage with and target consumers across a growing number of media. And the last one is use of data. So because of the digital advertising characteristics, the advertisers use or rely on data to enhance the economic feasibility, efficiency, effectiveness, and entertainment, which, as I mentioned, the 4E of their advertisement. So measure performance, enhance consumer engagement, etc. things. And data is broadly available to advertisers from a variety of sources, like data management companies and data aggregators and direct purchase from companies, data from the advertising venue, etc. Those of things. So audience segmentation is more efficiently determining the consumer preferences, and also it's possible targeting marketing, and this is important for product recommendations and digital advertising and email drip campaign use data analytics to deliver more relevant content to consumers. So from the business perspective, actually targeting marketing is also very important, not only for advertisers as well as consumer side data. And result measurement is also very important. And the advertisement campaigns can be measured and adjusted in real time for budget optimization. So budget optimization is also a very important issue, especially for SMEs, so small and medium enterprises. This is what I prepared for this session. Thank you very much.
Thank you, Professor Kim, for the excellent and interesting presentation. And thank you for being on time for the presentation. Professor Kim explained the characteristics and trends of digital advertising platform from a business perspective. The next discussant is Professor Yong Lim. Professor Lim is an associate professor at Seoul National University Law School. He is also the co-director of the AI Policy Initiative at SNU's Center for Law and Economics. His area of specialty includes antitrust and competition, consumer protection, information technology law, and privacy and data protection law. Professor Lim, please start your comments, and keep in mind that you have 10 minutes for your comments.
Thank you. Thank you for inviting me to this wonderful symposium. And I really enjoyed Professor Kim's overview of the ad industry in Korea. I'd like to also note that I really enjoyed the previous sessions and the discussion, in particular Professor Yee's point about sequential transition, which I really think is an incisive point. And I'm also pleased to have two business professors here, because I think it's really important that we incorporate business strategy insights in addition to economics when we talk about competition law. Now, with the 10 minutes that I have, I'd like to make a few observations about the current controversy surrounding competition in digital advertising markets. Digital advertising is a complex matter in terms of the type of channels, categories that we're talking about, solutions, players, and technology that make up and participate in the ad tech stack. And so there are numerous factors that would come into play, but I believe that there are two phenomena that are driving these controversies. And I believe that it's important to approach the controversies with these phenomena in mind. And they are, number one, the strengthening of privacy protection by gatekeepers, and number two, the emergence of full stack ad tech. This is a capture of a screenshot in my iPhone. And the app that I use, dictionary.com, asked me whether I would allow it to follow and track me over different websites and apps. I declined. It then pitched me once again and asked me to support it, and I declined again. Apparently, most iPhone users make similar choices. And so at this time, about 8 out of 10 users will not opt in. Now, this has led to concerns in the market about Apple's iOS 14 update upending the online ad market. And there was a lot of news about Snap stock price plummeting last week. But I should note that the impact seems to be different for various companies. For example, Twitter seems to have relatively survived unscathed. And I think this shows that there are actually differences between business models, even among ad-supported businesses. And I think that's a very important and interesting point. And I think it also shows you the importance of having access to first-party data. And again, that would be very relevant to antitrust analysis. The second phenomenon is the emergence of full-stack ad tech. And what I mean by full stack is where an intermediation service provider covers the entire intermediation process, all the way from publisher ad servers, supply-side platforms, the ad exchange, demand-side platforms, advertiser ad servers, the entire process. And so these full-stack platforms caters to both publishers and advertisers. Now, if you look at the allegations that are coming out from the current controversies, you can root most, if not all of them, in either one or both of these two phenomena. There are allegations that argue Apple and Google have weaponized privacy to exclude rivals and harm consumers. And many of the allegations in cases involving big tech argue that at least one aspect of consumer harm is non-consented reduction of privacy. So you have these allegations rooted in the first phenomena. There are also allegations that full-stack ad tech platforms have inherent conflict of interests, as they cater to both sides of advertising, and that the combined lack of transparency in the terms and price of intermediation have led to harm to consumers. So there are also allegations, more specifically, that full-stack ad tech, namely Google, have favored their own segments and services over rivals, which has resulted in the distortion of competition, similar to what you would see in a vertically integrated entity engaging in exclusionary conduct in traditional antitrust. So there are numerous cases currently being investigated or pursued, and what I would like to stress is that these are allegations that are currently being investigated or being challenged in front of courts. So I think it's a bit early to come to decisive conclusions at this time, but there are more, what you might say, conventional allegations. For example, excluding intermediation rivals from ad inventory, so exclusive dealing type of conduct, tying, and also what some have started to dub as privacy fixing, so anti-competitive agreements between parties to restrict competition. There are also somewhat more controversial or sometimes esoteric allegations where you have charges of preferential access to data, differentiated interoperability, favored placement, coarse bundling, etc. within ad stack, and what people would broadly reference as self-preferencing. There are also allegations of predatory privacy, which would be unilateral privacy protection measures, deceptive exclusionary misuse of data, and also, as was extensively discussed in the previous session, deceptive exploitative misuse of data, which is indirectly also related to the ad industry. Now, I'd like to just make a few observations, 3, and conclude. I think it's important, and I think that was what Professor Kim pointed out, to be mindful of the enormous benefits and efficiencies that ad tech has provided. And there now at this time seems to be a somewhat negative connotation when we talk about personalized advertising. And so even the Korean government differentiates or is attempting to differentiate between personalized advertising and non-personalized advertising, and is looking toward increasing the cost of personalized advertising for businesses. Now, I think it's important, though, that we remember and go back to the baseline, which would be the pro-competitive role of advertising, specifically personalized advertising in the market, and the benefits of ad tech that have allowed the flowering of ad-supported ecosystem in business and in markets, where many small and medium-sized businesses have access to ad inventory, which would not have been possible under the previous offline ad ecosystem, in an automated process which has enormously reduced transaction costs. So I think it's really important to remember and start from that baseline. At the same time, I think it's also important to parse through these assumptions and generalizations when we really delve into online advertising markets and competition concerns, and to carefully examine whether the assumptions that we used for offline advertising hold the same or are at least as robust when it comes to digital advertising. The second point I would like to make is that the real elephant in the room is remedies. And I think that's a point that has been made in previous sessions. So for example, let's look at the French authorities' settlement with Google and the commitments that came out of that case. In that case, the analysis focused on one side of the process. So it was specifically publisher ad server and supply server platform segments. Naturally, the remedy was also one-sided. And what that resulted in was that the analysis and both the commitment does not fully capture the benefits and harms, for that matter, that stem from the advertiser side of the process, and there was no balancing. And so, and again, there's also a lack of real consideration of the efficiencies of having a full stack service. So this is partly the result of market definition, which was a deliberate choice by the regulator, but I believe it runs the risk of facing the same pitfalls of looking at one side or only one side of a multi-sided market, whether it be from the perspective of anti-competitive harm or efficiencies. So unsurprisingly, there are now criticisms that the remedy or the commitments that Google made is insufficient to resolve the true concerns that stem from full stack ad tech. So as any competition matter, I think it's important that we consider and think about remedies from the get-go. When we start the analysis, when we bring and consider the liability theory, the ACT, as Professor Yi pointed out, from the beginning, we really need to think about remedies. The final point that I would like to make is about privacy and competition. And I know that we talked about it at length, but I'd like to make 2 additional small observations in addition to what was just discussed. Commissioner Ulhausen wrote a paper about competition, consumer protection, and the right approach to privacy, which I read years ago. And I think she shared similar insights today during her comments. And I would agree with many of the points she made in that paper. Another former colleague of her, Julie Brill, who was also a commissioner at the FTC, wrote a paper, Competition and Consumer Protection, Strange Bedfellows or Best Friends, about the interplay between privacy and competition. And yes, they do seem to be an odd couple. And I think we're really seeing how that can play out in the ad tech industry. Now, I've observed a few statements, particularly in the EU, about gatekeepers being quasi-regulators, or that we could harness them as quasi or de facto regulators. I think that also comes out in the Kremer report. Now, I think we have to be very careful about that, because you can penalize big tech for undermining privacy and demand that they do something about it, but then this is what you're going to face with. And so you turn around and then you start to say, well, you're weaponizing privacy, and so you should not do that as well. And so, again, the question then becomes, well, what do you really want? And so I think it's going to be a very thorny issue. And so on the one hand, we're going to say that, well, there are privacy harms. That's an antitrust matter, a reduction of privacy. We need to think about that. At the same time, when businesses say that, well, we are protecting privacy, and so that is an efficiency, then are we going to say that, well, no, this time that's antitrust, anti-competitive conduct? And so there is a tension and, in a sense, a true civil war within antitrust. In Korea, and I think this is a very important point that I would like to make, the message right now is that personalized advertising is not an ideal way to conduct business. There are various legislative initiatives coming out saying that, well, if you're going to do personalized advertising, you need to do this and this and this. You must get consent, etc. You know, we're increasing costs. What this means is that, at least from an incentive point of view, well, then businesses should move away from an ad-supported business model to a fee-supported, subscription-based business model, right? And in fact, that has been one of the mysteries in the digital economy, where people have questioned, why don't we have a robust, fee-based business ecosystem? We are now observing that coming out in the digital economy, I believe, worldwide. But at the same time, what the Korean government and officials are coming out, and the National Assembly is saying that, well, you should not raise fees. Charging fees is exploitative. You're abusing your position. And so we now have a plethora of legislative bills coming out saying that that's illegal. Now, then again, what should businesses do? So on the one hand, you're incentivizing, or it seems like you're trying to push businesses toward a fee-based, fee-supported business model. But at the same time, you're restricting businesses from exercising that fee business model. And so this is really going to be a conundrum for businesses. And I've heard from startups saying that we are really worried about our future ability to charge fees. And so there's a debate within these startups and online companies that we hope will be the next neighbor, the next Google, the next Kakao. And they're debating whether should we stay with the ad-supported business model, should we try and do a fee business model or subscription-based business model. At the same time, the cost of personal advertising is becoming higher. At the same time, what happens if we even try to charge fees? What is going to be the blowback? I think it's very important that we think about that, coordinate, and that's why my final question was, perhaps we need to collude in terms of, or at least coordinate between different policies and different agencies within the government when we think about digital platforms and specifically ad tech. Thank you.
Thank you, Professor Lim, for your invaluable comments. Professor Lim explained about the online advertising from the viewpoint of competition concerns. I also listened to the data-related discussions in the session 2 with big interest. And Professor Lim gave us comments that is related to session 2 as well as the digital advertising. And now, as the last commentator in this session, Director Moon at Korea Fair Trade Commission will give us her view and insight. Let me briefly introduce Director Moon. She studied economics at Seoul National University. Also, she holds a master's degree in economics at Seoul National University and LLM degree at UCLA. In the KFTC, she has been in charge of Consumer Safety and Information Division and Technology Appropriation Monitoring Team and Fair Economy Team. Director Moon explained online advertising from the perspective of consumer protection. Director Moon, once again, it would be appreciated if you pay attention to time management. Yeah, please start.
예, 안녕하세요.
Yes, hello, my name is Seong-Seung Moon from the KFTC. I'm in charge of Consumer Safety and Information. First of all, I'd like to thank the organizing committee of the APCC. Thank you for inviting me. So for session 3, we did have 2 prep meetings. Professor Im said he would talk about the competition law aspect of digital advertising, and I said I would talk about the consumer's perspective. And so when we think about online advertisement, the biggest problem that comes to mind are the personalized type of advertisement and then the backdoor type of concealed advertising. So let me touch upon those aspects. Now, with COVID-19, there's been a rapid adoption of digital across the board. You may know YouTube, Instagram, or Naver, and also Kakao are now providing a lot of exposure to advertisement. And so not only commercial products, but actually there's what's called Consumer 24. We have public good advertisements that are also listed on Naver, Facebook, YouTube, Kakao. So nowadays, it's quite a universal default go-to mode of listing advertisements online. And then live commerce is also very active, viral marketing as well, AI, audio also very prevalent. Now, the sound of people eating, ASMR, the sound of people, tapping on, makeup, ASMR is used in advertising, and metaverse billboards are used. Their endorsements with AI characters or celebrities also. So online platform is becoming a mainstream distribution platform, really informing consumer choices. And its influence is growing, but there is the possibility of damaging consequences, consumer damage caused by false, exaggerated, or deceptive advertisements. As Professor Kim has mentioned, online advertising has a lot of economic feasibility, also very effective for advertising purposes. So lots of businesses are thinking of different modes of advertising online. So for consumers, it's an easy, quick way to acquire a great deal of information online. But ironically, because there is great diversity in the advertisements, new diverse forms of damage to the consumer has also been emerging. So the KFTC, as a responsible organization for consumer protection, wants to, of course, minimize these damaging results. If you look here, this is a Gallup study showing the factors that really influence your product purchase choices. So TV ads, in-store advertisements. Well, you see the different channels, but you see now social media reviews are actually having a greater impact. For certain listings, however, they may distort or mislead consumers. hurt businesses and also consumers. For the businesses, for food delivery apps or accommodation booking apps or online sites, there's the issue of malicious reviews. There was a unfortunate incident where one business owner recently took his life because of that kind of malicious review by the consumer. For us, of course, we're focused more on consumer protection. If you look at unfair advertising, it is also becoming more prevalent on SNS channels. We call it backdoor advertising. So they may have received some compensation from the advertisers, but they pretend as if they bought a certain product with their own money. And so we're seeing that kind of deceptive ad in the form of recommendation or endorsement. And we're trying to crack down on this type of practice. In November 2019, the Korea Consumer Agency did a consumer study and found that about 30% out of hundreds of posts by 60 top influencer accounts in Korea, only 30% stated that they were putting up a sponsor commercial, that they had indeed gained some monetary compensation. That means 70% do not state the fact that they receive compensation. Sometimes it's in very hard to read, tiny letters, and so many times customers cannot recognize the information. So to resolve this issue, the Kftc amended guidelines on review of labeling advertising regarding recommendation and endorsements to require disclosure for each of the social media platforms, YouTube, Naver, web blogs. So by media platform, provided guidance on what kind of disclosure would be required in the case of sponsorship or endorsement. Also, to improve the understanding of the users, we also distributed a detailed guidebook with images and also FAQ in August last year. Also, to effectively remove unfair advertisements, we have been regularly monitoring dishonest social media ads since April this year. We have not had actually a case where we have imposed sanctions yet. These dishonest social media ads mostly concern small mom and pop type restaurants. Sometimes it's quite suspicious. Somebody would put up a picture of a huge metal pot that the owner, labors over 24/7, taken from the kitchen. The kitchen of a restaurant usually users would not have normal access to. So it does raise questions as to whether it is from an actual user. But we are monitoring these types of advertisements and also posts. So we do notify users about possible legal nature or illegal nature when we find certain advertisements that are questionable. So 4,500 blog ads, 5,000 or so Instagram ads were subject to voluntary correction by the posters. And then, yes, so YouTube and other SNS channels received recommendations from the Kftc to correct these types of dishonest ads. In serious cases or where there is repeated misconduct, we will undertake strict sanctions certainly to support consumers in accessing more accurate information on all products. And we heard about metaverse actually from a prior presentation. So when I'm talking to my colleagues, in the office, what about an avatar receives an endorsement and is wearing a t-shirt gifted from a brand, and then this avatar appears on metaverse, says, "Oh, I love this fabric, it's flexible and it's a good fit." Then does this qualify for some kind of monitoring or sanction by the Kftc? And so I think I just want to illustrate that we are increasingly looking at new practices that are emerging in this constantly evolving context. Now, personalized advertising is another big trend. Nowadays, big data Analytics has led to a very big increase in more personalized advertising. I met people in the advertising industry and they said that by nature, advertising in itself is personalized from the beginning. But at any rate, for the users, it's about customization of the content to products that I may be more interested in. So there is that kind of positive aspect, which Professor Im also mentioned. But then on the other hand, for the consumers, they do have some concerns. Mainly, the biggest concern would be whether the personalized ads can adequately reflect their dynamic interests. So I may be interested in something today, but not interested tomorrow. Say yesterday, I, for whatever reason, just spontaneously clicked on a pair of sunglasses that I really don't really like. What if they think that this is my preference and they recommend similar types of sunglasses to me? So there might be, confusion on the part of the users in those cases, and there are those concerns that the personalized ads may not really be able to follow their dynamic change in interests. So this was found as part of research by the Korea Internet and Security Agency. And the Korea Communications Commission, the KAIST, developed in 2017 a set of guidelines on privacy and online behavioral advertising. So even if it's the same website, so depending on the PC or mobile terminal that you use, different ads may pop up. So maybe it reflects clicks or searches that I may have done in the past. So in that case, according to the guidelines, they would qualify as personalized advertisements. But despite the guidelines, it's hard for the user to tell the difference instantly whether the ad that they are seeing now is just regular advertisement or whether it is personalized advertisement. And because this is just in the form of a guideline, it does not have legal binding effect, so there are limitations in terms of its effect as well. Many personalized advertisements actually do not get prior consent, opt-in from the consumers because they only offer opt-out options. So in terms of consumer protection, this may be seen to limit consumers' rights to choose. And even when the opt-in approach may be applied, consumer protection is not fully guaranteed because it does not clearly articulate the purpose of use of the customer information. It's hard to find where the terms and conditions are outlined, etc. And then children can be a big issue compared to adults. Of course, in terms of purchasing decisions, they can be very spontaneous and immature. So exposing children to personalized advertisement is something that has to be done with greater caution. The BEUC, which is a consumer organization in Europe, in February this year, actually raised a case against the Chinese video sharing platform TikTok to the European Commission for unfair terms of service and failure to protect children. Apple also strengthened consumer protection sometime this year by updating the iOS software to prevent advertisers like Facebook from tracking customers' search and usage history in the application. So they're now requiring prior permission and consent from consumers. So it does seem that generally things are moving toward greater protection for consumers. For the KFTC, to better protect consumer rights and respond to personalized advertising, we are working on the full revision of the Act on the Consumer Protection in Electronic Commerce. So most of these ads happen 100% online. So the special act on consumer protection and electronic commerce should apply instead of just the regular labeling or advertising law. So the proposed revisions will require that the content and method of personalized advertising shall be notified to the consumer in advance, and the consumer should be allowed to choose whether to receive it or not. So the intent is to guarantee consumers' right to know and tell what is personalized advertisement or not, and it's also to ensure the consumer's right to choose just an ordinary, regular advertisement over a personalized one. So these are the proposed revisions. Sorry, I think we're tight on time, so I think you could read that section later on, so I will just skip. And for regular consumers, they're asked to check off whether they agree on terms and conditions. So, I myself also just, scroll down very quickly without reading them carefully. And that's the case for most consumers. So I may have agreed, but then later on, if something happens and goes wrong, I'll say, oh, did I ever agree to this? So we feel that lots of consumers misunderstand their personal information has been infringed without even realizing. So this can be prevented in advance when sufficient data is provided to consumers through the revision of the E-Commerce Act. And the Labeling Advertising Act also has general regulations similar to the E-Commerce Act. So Labeling Advertising Act has a fuller scope. It applies to all businesses. E-commerce is more specific to e-commerce. So which act will prevail first? The E-Commerce Act says that the provision that is to the best interest or in the best interest of the consumers shall prevail and apply with precedent. So in terms of the substance, provisions of the Labeling and Advertising Act by and large apply to all businesses. But for live commerce streams, which are very volatile, they disappear after live airing. But then the E-Commerce Act will have specific provisions requiring that copies of the recording be kept for record. So those more specific provisions are provided for, more specific to the online context in the E-Commerce Act. Now, offline and personalized advertisements. So in terms of the method or the contents, I talked about some similarities and maybe differences. In the future, we plan to prepare policies and systems that better guarantee consumers' rational purchase choices in terms of content and the method of personalized advertisements. We'll handle personalized advertisements with that has inappropriate content by enforcing relevant laws. So there are many concerns and issues, but personalized advertisements can also be of benefit. They can be optimized to individual consumer needs and help inform rational purchasing decisions. So there are these pros. So the Kftc, which is responsible for consumer policy, will work to ensure to minimize adverse effects while making efforts to support consumers' purchasing choices and prevent damage by ensuring that consumers receive accurate information both online and offline. Thank you.
Thank you, Director Moon, for the detailed and informative comments. Director Moon explained well about consumer issues related to digital advertising and KFTC's policy responses. With the rapid change in the advertising market, there seems to be a regulatory blind spot that we are concerned about. Okay, it was a great opportunity to listen to these three expert presentation and comments. Thank you again for your great presentation and comments. And I think we have a few minutes for the question from the floor. Do you have any question for the three panelists on the podium? And okay, then due to the time constraint rate, I will just ask one simple question to Professor Kim. And listening to the comments of the three panelists, I think that the rapid changes in the online advertising market should accompany the change in regulatory method and regulatory targets. I'd like to ask what Professor Lim think about this.
Okay. So If okay, I will try to answer the question in Korean. 우선은
Well, first of all, so I just got the question now, and it occurs to me that as a person studying innovation, I'm looking from the corporate's perspective how they can secure sustainable competitive advantage working with limited resources. And as I listened to input from the panelists, it occurred to me that there's a very famous saying in innovation that innovation is always a double-sided sword. Companies that do not innovate are pushed out of the market, but excessive innovation could mean bankruptcy. So it's about balance. I think regulations also have that kind of double-sidedness. If it's too much, excessive, it can push companies to the brink of bankruptcy. If there's under-regulation, that also can lead to problems as well. On the platform side, so I do study a lot of entrepreneurship cases, so looking toward how to promote corporates. So we're always talking about how to encourage the platforms. So people who start up their businesses, when I meet them, which is often, I think about 60% of their business models are geared toward the platform because they're working with limited resources and really represents the most attractive new business model that they can use. So on the regulatory front, I do relate and agree with what has been said, but it's about how to intertwine that kind of regulatory piece together with innovation on the other side. So for example, we have to consider the unique characteristics of platforms. So the existing understanding of the conventional value chain, that kind of approach, definitely cannot apply in the new platform ecosystem. So it has to take a different shape, different form. So I think that is something that we have to give greater thought to in terms of shaping our approach. And also the underlying structure of Korean industries is something that we have to consider as well. I think it came up in a previous session. I really related a lot. But regulating platforms, regulating digital advertising, there are lots of cases that are cited, and we often hear of EU cases. This is just my personal view, but I think that from the Korean perspective, given the Korean industrial structure, it is quite different versus EU. So it's not a direct match. Of course, this is for advertising platforms, but in the EU, the biggest issue is the issue of duopoly, whereas in Korea, in relative terms, we have more of a healthy ecosystem with more players, although that could be subject to argument. So in some sense, I think that promoting the industry should be a focus for Korea in the Korean context as we try to decide on the regulations. So between government regulations, advancement, innovation of corporates, the two sides are very closely tied together. Promoting the economy, promoting economic activity, maintaining market order. So all of these things, I think, have to be factored in on balance in defining the policy mix.
And last one, Professor Kim, is there anything else you would like to respond to in response to the panelists' the comments of Professor Lim and Director Moon? Any reply, response? Yeah. Yeah, it's okay. And we are out of time, and I hope all of you enjoy this session. I close this session with my thanks to Professor Kim and Professor Lim and Director Moon for your excellent presentation and comments. Thank you.
With session 3, we come to the end of today's symposium. We would like to once again thank the expert panelists joining us in person and virtually, and also participants watching the symposium online, and all staff. I wish everyone good health. Thank you very much.